Good afternoon, ladies and gentlemen. Welcome to Amity University, a research and innovation-driven university. Amity University today is 12 universities in India with 16 global campuses, 28 schools and preschools. We are nurturing talent at every stage of life of our dear students at the school and the university level, following the vision and the mission of none other than our founder president, Dr. Ashok K. Chauhan sir, and led by the dynamic leadership of our chancellor, Dr. Atul Chauhan sir. It is said that there really can be no peace without justice. There can be no justice without truth. And there can be no truth unless someone rises to tell the truth. And the truth is justice. And the justice is truth. And that is what we hail in our scriptures, Satyameva Jayate. Good afternoon, ladies and gentlemen. Welcome to the fourth edition of the International Conference on Comparative Law 2023 in collaboration with School of Business and Law, Edith Covell University, Western Australia, together with Amity Law School, Noida. We are your hosts for the day. Well, the Constitution of India gives ranging powers and jurisdictions to do complete justice between the parties to bring to life the motto of the Indian Supreme Court, Yato Dharmas Tato Jaya. Wherever there is dharma, there is victory, and this is what the Lord venerates in the Bhagavad Gita. Today, up the panel with us in the valedictory session, we have with us Honorable Lordship, Honorable Mr. Justice A.H.M.D. Nawaz, Judge, Supreme Court of Sri Lanka. Her Ladyship, Honorable Ms. Justice Mini Pushkar Ma'am, Judge, Delhi High Court. Her Ladyship, Ms. Najat Abu Chakra Ma'am, she is Investigative Judge at the Military Court, Beirut, Lebanon. We are also graced by our Honorable Chairman, Professor Dr. D.K. Bandyopadhyay on this virtual dais, together with our three additional directors and HOIs, Professor Dr. Aditya Tomar sir, Professor Dr. Arvind Bhanu sir, Professor Dr. Shefali Raizada ma'am, Professor Dr. Aditya Tomar sir is also the conference chairperson from India, and we are also joined by Rupendra sir and Ms. Dr. Kriti Parashar, they are the conference co-conveners, and Jane ma'am, who is the conference convener. Well, let's begin this ceremony with lighting of the lamp, accompanied by an invocation that is dedicated to the light in our lives. I now request my colleague, Mr. Dr. Rupendra sir, to kindly share the lighting of the lamp with you. I request everybody to join the lighting of the lamp ceremony.
भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात् धियो यो नः प्रचोदयात् हे शारदे मां हे शारदे मां अज्ञानता से हमें तार दे मां हे शारदे मां हे शारदे मां अज्ञानता से हमें तार दे मां तो श्वेत वर्णे कमल पे विराजे हाथों में वीणा मुकुट सर पे साजे तो श्वेत वर्णे कमल पे विराजे हाथों में वीणा मुकुट सर पे साजे मन से हमारे मिटा दे अंधेरे हमको जालो का संसार दे माँ हे शारदे माँ हे शारदे माँ अज्ञानता से हमें तार दे माँ अज्ञानता से हमें तार दे माँ अज्ञानता से हमें तार दे माँ.
That's beautiful. Let the goddess of learning be exalted and take us on the path of righteousness, that which would enlighten us and guide us towards immortality. Ladies and gentlemen, at Amity, modernity blends with tradition. And to keep the tradition alive, we would now warmly welcome our guests for the day, with 2C saplings virtually to our esteemed and distinguished guests of this panel in this international conference. I request Rupendra sir to share the video. To Honorable Justice Vice Chancellor, Amity University, and Professor Dr. D.K. Bandyopadhyay, Chairman, Amity Law School, Professor Justice Ms. Mini Pushkarna Ma'am, Judge, Delhi High Court. Justice Ajay Chakra Ma'am, Investigator. Western Australia. Honorable Vice Chancellor, Chairman, Amity Law School, Noida. Thank you so much, everybody, for doing the honors and your leadership and your lordship for gracing the occasion. Well, everybody, Mahatma Gandhi once said that truth will never damage a cause that is just. Truth, justice will always prevail, they say. Well, India taking up the G20 presidency, it has become the responsibility of every citizen of the country to get involved in the inclusive growth which the Honorable Prime Minister talks about. And we are very proud that at Amity University, we follow the ideas of Honorable Founder President Dr. Ashok K. Chauhan, sir. We could go ahead with the 4th edition of International Conference on Comparative Law. Credit also goes to Professor Dr. Aditya Tomar, sir, who conceptualized an international conference which could talk about comparison of laws that started 4 years back. One person who believed that there can be such a conference which could talk about unification of laws in the entire world. And keeping that in mind came International Conference on Comparative Law 4 years back. The credit entirely goes to Professor Dr. Aditya Tomar, who we always look up to for any academic work at Amity Law School, Noida. This is with great delight, pleasure, and honor and respect that I would now invite Professor Dr. Aditya Tomar, Conference Chairperson and Additional Director, Amity Law School, Noida, to present the welcome address. Over to you, respected sir.
Good afternoon, everyone. Dignitaries on and off the virtual dais, delegates of the conference who have joined us online and offline, dean, directors, faculty members of the different academic institutions, distinguished guests, students, ladies and gentlemen. On behalf of entire organizing committee of International Conference of Comparative Law 2023, I welcome you all to the valedictory ceremony of 4th edition of International Conference on Comparative Law in collaboration with the School of Business and Law at Coven University, Western Australia. The first edition of this coveted event was held in 2019, and since then, ICCL has carved a niche with a rich and proud global academic collaborations in legal education and law practice, deliberations, policymaking through discussions and debates, which have consistently been in sync with the learning and comparisons of the legal system across the globe. Today, we are honored to have with us our distinguished chief guest of the function, Honorable Mr. Justice H.M.D. Nawaz, Judge Supreme Court of Sri Lanka, Honorable Ms. Justice, distinguished guest of honor, Honorable Ms. Justice Mini Pushkarana Ma'am, Judge Delhi High Court, distinguished guest of honor, Honorable Ms. Nazat Abu Chakra, Investigative Judge, Military Court, Beirut, Lebanon. We are most humbled and delighted and honored with your being presence, ma'am and sir. Thank you for your gracing the occasion, honorable lordships. Amity in itself is very own universe. The vision of our respected founder president, Dr. Ashok K. Chauhan sir, has been transformed into internationally benchmarked campuses that has come to epitomize the Amity Education Group. Currently, the group comprises 13 national and 14 global campuses across New York, Romania, London, Singapore, Dubai, South Africa, and other places. Keeping up the integrity of our universe, our dynamic Honorable Chancellor Dr. Atul Chauhan sir of Amity University, Uttar Pradesh, and Patron-in-Chief of ICCL 2023 has led Amity University under his dynamic and inspirational leadership, which has led us of feet not only nationally but also globally. We are honored with the virtual presence of Dr. Balvinder Shukla ma'am, our Honorable Vice Chancellor ma'am, who always guide and motivate us all the way. We are honored to have our kind presence of Professor Dr. D.K. Bandyopadhyay sir, our respected Chairman sir of Amity Law Schools, who helped us right from the beginning of the preparations of ICCL 2023 and guided us all the way. Comparative law helps us to evaluate better law comprising different countries, helps to analyze the pros and cons of the legal mechanism and find a middle ground for the better laws of work smoothly. There are issues of freedom and discrimination that are not limited to one space or reason, and application of such principles in other legal systems allow a new way of thinking and applying such law in one's own country. These principles are not necessarily binding in courts, but are used in comparisons and to provide a clear picture of the policies being followed. The main aspects of the comparative law is the harmonization of law at the international level. The comparative method provides similarities and differences in the legal system and thus helps to create a common platform to reach consensus on certain issues. I'm sure that deliberations during the conference yielded a substantial outcome in the area of legal education and research for global good. I congratulate each and everyone who has presented papers, talks in the conference, and also everyone who has attended this conference. Thank you very much.
Thank you so much, Professor Dr. Aditya Tomar, sir, for giving us this international conference. Well, everyone, I remember William Godwin, who once said that the cause of justice is the cause of humanity, while it advocates that there should be an overflow with universal goodwill. We should love this cause, for it conduces to the general happiness of the mankind. And this is also how these international conferences help build what we call as universal brotherhood, camaraderie. And in India, what we believe in is fostering friendship beyond borders, Vasudhaiva Kutumbakam. For the entire world is but one global village. Having said so, I now request Professor Dr. Arvind Pubhani, Additional Director and Joint HOI, Amity Law School, Noida, to present the opening remarks. Over to you, respected sir.
Thank you. Thank you, Dr. Sumitra ji. Am I audible, Sumitra?
Yes, sir, audible, sir.
Okay. So before stating any word, I would like to extend my warm welcome to Honorable Miss Najat Abu Chakra, Investigating Judge, Military Court, Lebanon. Honorable Justice Mini Puskarana ji, Delhi High Court. Honorable Mr. Justice AHMD Nawaz, Judge Supreme Court of Sri Lanka, and our respected Vice Chancellor Ma'am, Professor Balvinder Shukla ji, and our Chairman Sir, Professor D.K. Bandyopadhyay ji, my colleagues, and all participants. As I first of all refer to the inaugural session where 3 judges from different high courts graced the occasion, and they referred this comparative study of law in the light of the Constitution. We have seen that this international conference, which has been organized, this is the 4th international conference on Comparative Law in collaboration with the School of Business and Law, Edith Cowan University, Western Australia, has witnessed so many overwhelming response from India and abroad. And there has been a lot of deliberation on comparative aspect on the law from personal law from constitutions, law from commercial field, and law from other fields. So there has been a lot of debate and discussions during these long technical sessions in this seminar. And I'm sure that we have all enlightened with the words of the wisdom from the legal luminaries, great personality from different fields. And I have seen, and I was also told that, yes, this time we have received, the overwhelming response from the researchers, academicians, even the other participants to this comparative approach of study to the law. I can say that, of course, there may be some reason which just pushing this study to acquire the new dimension of the study, a new dimension of the attraction of the researcher to come and study the comparative law. But you can see that just before this more than 7 decades, if we see our constitution, then we can say that our constitution is product of the study of comparative approach. I do not believe those who say, the critics say, that our constitution is a copy-paste product. I do not even believe that those who say that is a borrowed one. I don't believe. But I believe that in place of those 2 types of the words, if you use, please use the word that our constitution is product of the comparative approach of the study. I'm just putting forward some example, keeping in the time which has been allotted to me, that in Constituent Assembly, 12 constitutions from different countries were studied. 12 constitutions at that time. The constitution from US, the constitution from UK, Canadian constitution, Irish constitution, French constitution, Australian constitution, constitution of Soviet Union, USSR, constitution of South Africa, constitution of Germany, constitution of Russia, constitution of Japan, and Government of India Act 1935. I am just calling it constitution also, because this was the act which was enacted by the British Parliament. It was treated as a constitution to the pre-independent India. So these were the documents which were debated and discussed in the Constitutional Assembly to come to that the constitution, the Indian constitution with which we are concerned here, which was, the implemented in 1950. Just, I would like to take one citation from this out of the comparative approach. It is well known that the fundamental rights, the part 3rd of Indian Constitution, has been taken, if I say so, from the American Constitution, United States of America. But I will say that it has not been copied. I will say it has not been borrowed. Why? Because I'm citing one example so that you can just take up that these words are not appropriate to use it. If you see the first amendment of American Constitution, by which the freedom of press was included in American Constitution. And our Constitution was also enacted. And in our constitution, through Article 19, the freedom of expression was included as a fundamental right in Article 19, Clause 1, Subclause A. So try to understand, please, that this freedom of speech and expression was having the corresponding debates and discussion to the First Amendment of the American Constitution. But see, please, that in Article 19, Clause 1, Subclause A, freedom of press is not given in express term, whereas in First Amendment of American Constitution, the freedom of press is specifically addressed. So it is very much clear that our constitution is not a product of the copy-paste. In Constituent Assembly, the First Amendment of the American system was debated, and the Constituent Assembly came into conclusion that the freedom of press was already implicit, covered by the right to freedom of expression, and therefore there was no need to include it as a separate and distinct right. My submission here is that whenever we study two branch of the subjects, two things, two circumstances, and where there is an intersection, there is an innovation. The strength of innovation comes. So this by studying, by debating, discussing, through this comparative approach of study of law, we not only get the best practices which is being adopted in other countries, in other regions, but we can come to the point where we can innovate something. So by putting this point, I'm just realizing and giving my point of view that this study of law through comparative approach is not confined to a single purpose, but it goes to serve the multi-purpose. Thank you. Thank you very much.
Thank you so much, Professor Dr. Arvind P. Bhanu, sir. With your opening remarks, I'm sure that we can set the ball rolling now for the valedictory ceremony, and this has also given us a new perspective. And with that, I remember Edmund Burke, who said that there is but one law for all, and that is the law that governs the all, and that is the law of our Creator. Well, that is the law of humanity, justice and equity, which He has set for the entire mankind. Well, thank you so much, ladies and gentlemen. We would now proceed further with the schedule, and now I'm going to invite one person who's been our mentor throughout this conference, none other than our chairman, Professor Dr. D.K. Bandyopadhyay. So one person who is a multifaceted scholar in the field of academics and research. He is a visionary leader, being awarded with so many national and international awards. Professor Dr. D.K. Bandyopadhyay is also the chief advisor to our honorable founder president, Dr. Ashok K. Chauhan, sir. Professor Dr. D.K. Bandyopadhyay, sir, is also in many of the committees of the government, and he advises Amity University on various ideas of research and innovation. And it is with his blessings and with his continuous guidance that Amity Law School, Noida, is soaring great heights. I would now request Honorable Chairman, Professor Dr. D.K. Bandyopadhyay, sir, to kindly address the gathering. Over to you, respected sir. Sir, you're on mute, sir.
Thank you, Sumitra. Thank you very much for your generous introduction, and which I don't think that I deserve so much of attention, because the valedictory function attentions are with our three lordships today. Lordship Justice Ahmad Nawazji, Lordship Justice Mini Puskaranji, Lordship Honorable Justice Najat Abu Chakraji. So today is their day. We are eagerly waiting to listen their wisdom. We have done our job in terms of bringing under 90 scholars 90 scholars, there are 180 papers were submitted on this, on the theme of the conference. About 90 was selected, and they came and deliberated on the different facets of the comparative law. Because we are very clear when we are trying to do it that, we are trying to do this conference, we are very clear what is the vision of our Honorable Founder President. Honorable Founder President all the time says that don't be a follower, try to become a leader. And Amity all the time, from its very inception, we have shown to the country and to the world that what Amity thinks today, others follow tomorrow. In different types of academic programs or different types of evolving academic processes. And with this vision, this comparative law concept came of research and also conducting conferences, first time in 2019, and from there it's ever ending. And this is the 4th edition that we are conducting it with a very basic theme that adopting a comparative approach helps us to delve deeper into one's legal system to assess and appreciate the similarities and divergence among legislations, legal institution, political framework, social ideologies, policies, and rules in corresponding jurisdictions. These comparisons be bilateral or multilateral, more than 2 legal systems, and this is the essence of starting this conference of the comparative law. Because in the globalized world of today, where there is a boundary, there is a territorial boundary. Within the territorial boundary, there is a territorial law as per their constitution and as per their legal systems. But nowadays, when the whole world is going to become a global village, and in that context, people are moving from one particular place to another particular place, and it has become a very, very imperative that we must also understand the prevalent laws of those countries, whether it's a constitutional law, whether it is the criminal law, whether it is the IPR, whether it is competitive, whether it's business law, whether it is family law. So these are some of the things that we thought, why not we explore the possibilities at least on 2-3 countries in understanding their law in existence of those countries. Now today, if we just look at how comparative law is being used, Dr. Bhanu has already mentioned about the constitution law, constitution assembly deliberations, and the type of constitutions were actually referred to. And from there, it has been evolved what is known as the great Gita of governance, that's our constitution. Now, if we just look at Information Technology Act today, now we have tried to understand what is happening in Australia, what has been happening in Singapore, what has been happening in Canada. And from there, we evolved our Information Technology Act, way back 2002. After that, it went on modifying it based on the requirement of the society, based on the requirement of the nation. And while doing that, we all the time try to compare what is our prevalent practices that are being done and in other countries, so that we are able to bring not only the justification or also the unification. The most important thing is the justification and the unification. And what are the different unification that we can bring by studying this comparative law? So this law scholarship, which has actually grown in a last few decades, if I just want to mention over here, global development, transnational governance. Now, most of the companies nowadays, we just see that they are not only multinational, but they are also transnational, and their governance is a transnational governance. The complex economic interdependency. What is happening in Ukraine or Russia, our Indian economy is actually going to be affected or impacted. what is happening in Germany is going to impact to India. And then what are going to be the different type of, competition laws should be in place, what should be the, tribunal, what are the different tribunals should be in place. Now the climate change. Now we have got different types of act in the climate for the climate governance. But what are going to be an integrated view of the climate change? What the other countries are doing, what the Swedes are doing, what Germany is doing, what UK is doing, and we have to understand their way of governance in terms of mitigating the climate change. So this has become much more important in the interdependent world. So it is the, and again, if you just see that communications information technology have contributed to making the legal profession more contemporary and than ever before. So the comparative law has become to look in it from its different perspective. It has become a necessity now that we must understand what is happening. And now this, if you just look at the arbitration that is taking place across the globe, and then Indian advocates or Indian arbitrators are on high demand because they not only know the Indian perspective of the legal system, but also they know the perspective of the other legal system. So in those perspectives, the law institutions or those who are interested in research in the different legal systems of different countries and their comparisons become very, very pertinent. And we found this could be the main reasons that we must focus ourselves, spend reasonably good amount of time devoting by the faculty members and in enhancing the researches in this particular area. It's a great effort done by Dr. Adit Kumar and his team, supported by Dr. Raizada and Dr. Bhanu, AP Bhanu, and in terms of making it to actualize it. I cannot but appreciate Edith Cohen University, Professor Joshua, who is our honorary associate professor, and he has been also collaborating with us. He has also given us some sort of a funding for the purpose of conducting this comparative law conference. And we are also to mention, and it would not be justifiable if I do not mention the contribution of the Adelaide University of Australia. They are the first one who came forward in terms of starting these comparative law conferences. So in a nutshell, once again, I'd say that these beautiful efforts that has been taken by the Amity Law School Noida, very progressive in nature, and this is befitting to the vision of our Honorable Founder President and Honorable Chancellor, that we are to be the leader, not the follower. And on behalf of the entire Amity universe, I welcome our Honorable Justices. Once again, Justice Ahmad Nawazji, Justice Mini Puskaranaji, Honorable Justice Mr. Najat Abu Chakre to our Amity universe. And it would not be out of place just to mention for about 30 seconds what this Amity universe is all about. Maybe Najat Abu Chakraji, you may be knowing it, and Mr. Mr. Ahmad Nawazji, you may be knowing it, but Justice Mini Puskaranji, maybe it's a new to Amity. So I would like to mention a few things about Amity universe. You see, Amity was established by one man, Dr. Ashok K. Chauhan, who was an industrialist in Germany, came back over here with one mission, how to provide quality education to the masses. And he visualized that only through the education, India can become a superpower. That is his dream. He thinks all the time, he dreams all the time, he eats all the time, that how to make India to become a superpower. And his formula for making India to be superpower is through providing quality education and different types of quality education. And through his tireless efforts, he has created 12 universities, 25 campuses across the globe. Students of Amity is spread over the globe, and many of our alumni are working in different types of countries. Although we are hardly 17 years old baby or old boy or old girl, you can say that. And within the 70 years, the way the exponential growth has taken place it is due to the 1 month's vision that is Dr. Ashok K. Chauhan, and again, which has been totally given impetus by his very, very able son, Dr. Utul Chauhan. And he all the time tells that, how do we make MIT reposition itself so that everybody thinks that yes, a student who is coming out of the MIT, it is coming with a different signature. He is coming with the up-to-date knowledge, he is coming with the skill, and he is going to contribute for the benefit of the mankind or benefit of the society. And all this philosophy, all this vision, we are all implementing here in this MIT University, and which is being spearheaded by the Vice Chancellor, Dr. Balbinder Shukla. So once again, I thank Dr. Aditya Tomar. I thank all my faculty colleagues who actually day and night work for this conference and mobilizing the people, bringing the papers, compiling them, editing them, and then rejecting them. Some of them, 50% are rejected, and they are going to come up with a book which is going to be Springer Publications book, and it's a great effort. I must thank Jane and Rupinder, and not the least Sumitra. Sumitra is all the time very vibrant, and he brings vibrancy, and he tries to unify everybody, and that is his uniqueness. So with this, once again, thank you very much. Thank you, everybody.
Thank you so much, Chairman, sir, for the beautiful words and also for presenting the opening address so very well. That we get another perspective of law, and I remember Lydia Maria Child who said that law is not law if it violates the principles of eternal justice. And while she says so, I remember William Gladstone who said that justice delayed is justice denied. So by having such conferences, we can talk about justice in broader sense. Thank you so much, sir. Ladies and gentlemen, boys and girls, it's a proud privilege to have amongst us our distinguished guest of honor, Your Ladyship, Honorable Ms. Justice, Ms. Najat Abu Chakra ma'am. She's an investigative judge at the Military Court, Beirut, Lebanon. Madam Ms. Justice Najat is an investigative judge at the Military Court in Beirut since October 2010. During this period, she's been and currently is in charge of several critical case files. Some are related to terrorism, like the sleeping cells case file of Ahmed Al-Asir and another for Saza Al-Dolaimi, Irsal Battles and Benin Battles case. And some are related to the finance of terrorism, and some are related to the contact with the enemy, war crimes and crimes against humanity, in addition to murder cases, torture, drugs trafficking, human trafficking, and minors which are involved in terrorism acts. Ms. Justice has been occupied by the post of penal unit judge at LA Court from June 2014 to October 2017, and the post of civil unit judge at LA Court competent of rental and real estate cases from March 2009 to June 2014. Madam was a member in the first instance chamber in the south of Lebanon with full jurisdiction from October 2004 to March 2009. Madam joined the Judicial Authority as an apprentice judge and permanent member of the courthouse in August 2001 and became an accredited judge in September 2004. Madam is an accredited trainer at the World Bank and an assessor at FATF. Ma'am has published many studies and articles in legal journals in Lebanon. In 2021, Madam has published a book which is titled Cyber Terrorism in Lebanese Law, which is a comparative study. Let us all welcome Madam Ms. Justice Najat Abu Chakra ma'am with a round of applause. Welcome, ma'am. Welcome to the International Conference.
Thank you so much, Dr. Zink. Thank you so much for your introduction. Well, my friends, good day to you all, and I am honored to be with you today and participate in this conference, the 4th Annual International Conference on Comparative Law. I have received the invitation sent by Dr. Zink with pleasure and gratitude for giving me the chance to participate again in these interesting and valuable conferences held by the reputable institution Amity Law School, Noida, in collaboration with School of Business and Law, Edith Cowan University, Western Australia. My first participation in this conference was on the 18th of February 2022. Well, I have chosen to talk about two topics today. The first one is the anti-torture law that was issued in Lebanon on October 20, 2017, under number 65. And the second one is the international crimes from the perspective of the Lebanese judiciary, and then I will be talking about how the Lebanese judiciary deal with these crimes. I believe it is known to everyone that international crimes are the 4 crimes listed in Rome Statute of the International Criminal Court that was adopted in Rome, Italy on July 17, 1998 and entered in force on July 1st, 2002, that are genocide, crimes against humanity, war crimes, and the crime of aggression. When talking about these 2 topics, I will not go on reading or mentioning the articles of law or the laws that apply to each. Instead, I will talk about 2 cases that I have worked on since I am an investigative judge in the military court. So allow me here to open 2 brackets and mention that the military court in Lebanon is not a martial court. It is not competent only to prosecute the military for committing military crimes, but it is also competent to prosecute civilians while committing several crimes listed in the military justice law, such as espionage, treason, arms trafficking, terrorism, financing of terrorism, and many more. Lebanon has different types of justice or courts. All are established under the Article 20 of the Lebanese Constitution. We have the judiciary courts, the administrative courts, the financial courts, the religion courts, and the military courts, where civil judges like me work in addition to military judges. The military court is formed of a court of cassation, tribunals divided into the permanent military court and the single military judges, the general prosecutor department, and the investigative judges department. All judges in these 2 departments, the general prosecution and the investigative judges, they are all civil judges. The head of the Court of Cassation is a civil judge, and there are 4 civil judges who are counsels in the permanent military court. I have talked about all these above mentioned issues in my previous participation on February 18, 2022. So let us move now to our first topic, the anti-torture law. As mentioned above, Lebanon has issued this law in 2017, while it had ratified the Anti-Torture Convention in 2000, which means, unfortunately, that the law was issued 17 years after ratifying the convention. This law criminalizes any act of giving, inciting, or approving the use of pain, of severe pain, physical or moral, to any person who is subject to inquiries, preliminary investigation, judicial investigation, trial, implementation of penalties, when committed by an official employee. Whenever this act leads to injuries or death of the tortured person, the act is qualified as a felony, yet it remains a misdemeanor if it doesn't lead to any injury nor death to the tortured person. In addition to this delay in putting the convention in force by adopting it through a law in the Lebanese parliament, the Lebanese judiciary didn't face any torture case until August 2022. It was when a picture of a dead body of a person, it was said to be a Syrian detainee, went viral on social media. The general prosecutor in the military court moved to the detention center and discovered that this Syrian person was arrested for being suspicious of terrorism and tortured until death by a captain and 3 officers in the State Security Agency. The general prosecutor discovered also 7 other detainees that were tortured and injured by the same captain and 1 of these 3 officers. He also found that there was an officer who was ordered by the captain to beat each detainee 1 slap only on the face, since he is huge and powerful. So 1 slap was enough to make the detainee afraid and ready to confess. The captain and the 4 officers were arrested. The file case was sent to my bureau to conduct the investigations. This file case affected the Lebanese public opinion since it was the first file case in torture crimes, and the first time for the Lebanese judiciary to apply the anti-torture law. Lawyers and NGOs in particular, and all the people in general interested in the application of the anti-torture law were happy to see that this law will finally be applied. They were so satisfied by the procedure taken by the general prosecutor than by me, since I have issued an arrest warrant against the captain and the 4 officers and accused them of committing a torture crime described as a felony for the captain and the 3 officers because they had caused the death of 1 detainee and the injury of other 7, whereas a misdemeanor for the officer who used to give only 1 slap to each detainee had not proven to cause death nor injury to any of them. The most important legal issue that I have faced while working on this case was the following. What justice was competent to pursue the captain and the officers? Was it the military justice or the judiciary justice? The family of the dead detainee asked to move the file case to the judiciary justice, relying on Article 15 in the criminal procedure law that states that each crime committed by the police agents while doing a judicial duty should be prosecuted before the judiciary justice. My decision was to announce the full competence of the military court, relying on the military justice law and its amendments that are special or exclusive laws and should be applied before the criminal procedures law, which is a general law. These special articles state that any crime committed by an officer while exercising his or her duties or while working with the military justice or under its competence should be prosecuted before the military court. Thus, since the torture was done by agents from the security state while they were executing their duties as investigators, and since the Syrian detainee was murdered while he was arrested for being suspicious of terrorism, a crime that falls within the qualitative authority or competence of the military court, and since the anti-torture law did not mention which court is competent to pursue the crimes that falls under it, then the military court should have full competence to hear this case. The final verdict in this case has not yet been issued. Let us move now to the second issue, the international crimes from the Lebanese judicial perspective. Referring to Rome Statute, these crimes should be prosecuted before the ICC, International Criminal Court, but Lebanon did not ratify the Rome Statute. So if an international crime is committed in Lebanon or by Lebanese, it could not be prosecuted before the ICC. But what really happened in Lebanon? We had a civil war from 1975 until 1990, when many war crimes and crimes against humanity were committed by the Lebanese militia, whose leaders unfortunately became, after the civil war finished, deputies in the parliament and ministers in the successive governments. Those militia's leaders, so-called politicians now, issued an amnesty law in 1990 to forbid any prosecution against them. The Lebanese legal system knows the ordinary crimes or local crime like torture, murder, kidnapping, rape that could constitute the elements of international crimes. However, it does not know the international crimes. That means the crime that affect the international peace and security. So this will lead to the incapability of the Lebanese court to pursue international crimes if committed in Lebanon or by Lebanese. This crime could not be pursued before the ICC for the reason that Lebanon did not ratify Rome Statute. This statute states that the local justice should take the lead to pursue international crime and that ICC will not hear the case unless it was proven that the judicial system in a country is broken, which was the case of former Yugoslavia due to the collapse of the Yugoslavian Union, or is incapable to act freely or seriously, which was the case of Rwanda. The Lebanese legal system knows as well the statute of limitations for all types of crimes. The Article 10 in the Penal Procedures Law lists that misdemeanors fall after 3 years of being committed and felonies fall after 10 years, while international crimes are not subject to any statute of limitation as the Article 29 of Rome Statute lists. On another hand, Lebanon has faced the Israeli occupation in the south of Lebanon, where a Lebanese militia cooperated with the Israeli army and committed many war crimes and crimes against humanity, especially in a detention camp in a village called Khiyam, where many resistant against the occupation were imprisoned, tortured, and killed. The Israeli occupation was over in May 25, 2000, and many members of this militia ran away to Israel, then to Europe or USA, whereas some resided in Israel. In 2019, a man who was a captain in this militia and the leader or chief of Khiyam detention camp came back to Lebanon from USA. He was arrested because he was wanted for committing treason, murder, kidnapping, and torture between the years 1982 and 1996. His file case came to my bureau. The legal issue we were facing is that this man did not commit ordinary crimes. He killed, tortured, and kidnapped many Lebanese citizens when he was dealing with the enemy, which is Israel, and then for being a traitor. My decision was to consider these crimes as international crimes war crimes and crimes against humanity that are not subject to statutes of limitation and should be prosecuted before the Lebanese judiciary, specifically the military court, because they were committed on behalf of the enemy, while committed a treason crime. Even if the Lebanese law did not stand up for this type of crimes, and because Lebanon has signed and accepted many conventions and resolutions of the United Nations General Assembly that state that countries are required to punish criminals, and that these conventions and resolutions set rules that are above the law, any local rule. After I sent the file to the Permanent Military Court, it considered that since the Lebanese parliament did not issue a law that criminalizes international crimes and that adopts the rule of no statute of limitation of crimes, then the Lebanese judge could not apply international rules and must comply to his local laws. The Permanent Military Court set this person free, and its decision was ratified by the Court of Cassation after the appeal of the General Prosecutor. Dear all, these were the two subjects that I like to share with you today. I hope that you have enjoyed it and it was of benefit to you. Thank you so much for listening.
Thank you indeed. Your Lordship, Najat Abu Chakra. So once again, we got the opportunity to listen to you second time.
Thank you.
Now,
Thank you.
We all the time say that Sumitra will further take it up. That, all the time we say that once an Amitian is all the time an Amitian. So you have attached, we have now got attached with us. Now you are going to remain attached with us for the time to come. So thank you very much. Thank you.
It's an honor and a pleasure.
Yeah, for accepting our invitation. Thank you very much.
Thank you. Thank you for inviting me.
Thank you, Your Ladyship, Ma'am, Honorable Judge, Honorable Justice, Ms. Najat Abu Chakra, Ma'am. As Chairman Sir rightly said, once an Amitin is always an Amitin. Ma'am, we can feel that connect virtually also. We can feel that. We can feel that connect of being an Amitin with you. We can feel that, emotion. Yes.
Look, we the Lebanese, we love India. I don't know if you know that. Especially from the region where I come from, the leader of my community used to visit India too much because he has a spiritual connection with India. So yes. We love you before I met Amity Law School, and now I love you more. And I'm so proud to be with you this year, the last year, and every year to come. So thank you so much.
We also love Lebanon. Indians also love Lebanon.
Yeah, we love you too. Thank you so much.
Thank you, Your Ladyship. Thank you so much for those beautiful words of emotionality and belonging. At Amity University, we celebrate the Day of Belongingness, where we celebrate our Honorable Chancellor's birthday on 7th May every year. And everybody who becomes a part of the Amity family, he or she, feels very much belonged. And with that belongingness, Your Ladyship, we love you so much. And now that you're a part of Amity, the belongingness is now strengthened. Thank you so much for gracing the occasion, ma'am. Thank you so much. Ladies and gentlemen, boys and girls, furthering up in this valedictory session, it is our privilege to have with us our distinguished guest of honor, Your Ladyship, Honorable Ms. Justice Mili Pushkarna Ma'am, who is Judge at Delhi High Court amongst us today. Madam Justice has completed her honors in political science from Hindu College, Delhi University, and her law degree from the Campus Law Center, Delhi University. Before being elevated, Ms. Justice has had over 25 years of experience as an advocate at the bar, during which period she has been the standing counsel for various bodies, including the Municipal Corporation of Delhi, Delhi Urban Slum Improvement Board, and on the Panel Service Department of Delhi government, and much more. Madam Justice has had varied experience in various fields of practice at the bar and has contested cases, including those related to tender and contract matters, arbitration, service lawsuits, etc. She is also on the panel of arbitrators with the Delhi International Arbitration Center. In her early years of practice, Madam has had done matters as lawyer with the Legal Aid and Advice Board, and has been a reporter for many years with the Supreme Court Reports, which is the official journal of the Supreme Court of India. Ladies and gentlemen, boys and girls, it is with much pleasure, honor, and delight that I now invite our distinguished guest of honor, Your Ladyship, Honorable Ms. Justice Mili Pushkarna Ma'am, Judge, Delhi High Court, of the panel to address. Welcome to Amity.
Good evening, everyone. First of all, I would like to extend my deep appreciation to Amity Law School, Noida, for organizing this momentous conference. I was informed that the third edition of the conference, held in February 2022, was a great success. And keeping in view the spirit of the same, I am delighted to be here today with all of you for the 4th annual international conference being held this year. The theme of the conference today, that is comparative law, is highly relevant today, a principle arising from the world's diversity of legal systems and the different approaches adopted to common problems. By examining multiple legal systems, in our increasingly globally linked world, comparative law needs to take an ever more crucial role. It is true that we are linked in more important common ways. Still, there are differences among areas of the world and the countries, notwithstanding our common linkages. And so that brings us to the topic at hand, that is assessing the role and the methodology of comparative law so that we understand the role of law in different countries as a way of promoting insight and knowledge and perhaps a measure of common understanding. It is not enough simply to compare words on the page. Law sits within a culture. Law both drives and is influenced by the culture of the home country. So we must look beneath the law as written formality in the text. We need to dig out the underlying structure of law to understand better what law really is and how it actually functions within a society. To do this, we need to explore the substructural forces that influence law. These can be things like history, geography, morals, the custom, philosophy, or the ideology, among other driving forces. Mahatma Gandhi envisioned our Indian Constitution as a set of universal principles that were applied to India's specific and unique circumstances. Gandhiji had penned his vision in as early as 1931, and in his words, and I quote, "I shall strive for a constitution which will release India from the thraldom and patronage. I shall work for an India in which the poorest shall feel that it is their country in whose making they have an effective voice. An India in which there is no high class or low class of people. An India in which all communities shall live in perfect harmony. There can be no room in such an India for the curse of untouchability. We shall be at peace with the rest of the world, neither exploiting nor exploited. This is the India of my dreams for which I shall struggle." Quote close. The Indian Constitution, a work produced after more than 2 years of vigorous debate and reflection, is an extract of the most admirable views and viewpoints shared by many distinguished members of the Constituent Assembly. To begin with, it should be remembered that Constitution, in our understanding, are not static documents written on stone. They are living creatures which evolve over time in response to the emergence of new social needs. There's little doubt that a country's social and cultural history have much to do with the origins of its constitution. The US and the Indian constitutions are important founding texts. The former is one of the earliest democratic constitutions of the modern era, while the latter is one which laid the foundation for the largest democracy in the world today. Soon after the declaration of the Poon Swaraj in 1930, which can be compared to the Declaration of the Independence in 1776 in the United States, every Indian decided not to compromise in achieving the complete independence, and the great minds of India believed indigenous constitution was the first right step towards it. Similar to this, the US Constitution had a significant influence on the Indian Constitution, despite the stark differences in the socio-economic situations. Having said that, despite different starting points, these two great democracies are founded on similar democratic and egalitarian ideals. Global changes in the political legal system frequently mirror contemporary international developments. Both US and India are countries that have long shifted from the system of monarchy to different systems of government. India is a country with the parliamentary system governed with the Indian Constitution, whereas the US adopted the presidential system of the government. it is not denied that the Indian Constitution is the supreme law of the land upon which the entire governance system is based. Our founding fathers chose parliamentary democracy as the form of government for the fledgling republic. Dr. B.R. Ambedkar explained why parliamentary democracy was preferred over others, and in his words, I will quote, "Under the non-parliamentary system, such as the one that exists in the USA, the assessment of the responsibility of the executive is periodic. It is done by the electorate. In England, where the parliamentary system prevails, the assessment of responsibility of the executive is both daily and periodic. The daily assessment is done by members of parliament through questions, resolutions, no confidence motions, adjournment motions, and debates on address. Periodic assessment is done by the electorate at the time of the election, which may take place every 5 to 3 years as earlier. The daily assessment of responsibility, which is not available under the American system, is felt far more effective than the periodic assessment and far more necessary in a country like India. The draft constitution, in recommending the parliamentary system of executive, has preferred more responsibility to more stability, quote closed. The constitutions, as we know now, have undergone a number of changes over time to incorporate both explicit and implied rights within them and to eliminate provisions that no longer suit the purposes of the society. Both have stood the test of time because they provided for flexibility. Decriminalization cases and other recent constitutional changes in India have centered on recognizing and accommodating societal requirements in order to avoid breakdowns. On the bright side, the fact that discussions about race and caste-based discriminations are occurring in common settings and are no longer restricted to academic ivory towers suggests that we, as a group, are undergoing a commemorative awakening with the promise of a bright future ahead. On one plate, we have the age-old cultural traditions of India, and on the other, we have the changing India, which is on its way to adopt culture, which gives us a sense of pride. After India gained independence in the year 1947, the dream of the constitution makers was to create a viable model of governance that would best serve the nation while keeping the primacy of the people at the forefront. The foresight and visionary leadership of the Constitution's founding fathers has bestowed the country with an outstanding constitution that has served as a beacon for the nation over the last 7 decades. Both constitutions of the UK and the India have parliamentary form of government, which includes the dual concept of close relationship between the legislature and the executive. However, the constitutions of India and the United Kingdom clearly distinguish between legislative and the executive functions. In India, the judiciary operates as an independent machine, free of interference from the legislature and the executive. Coming to the United Kingdom, the history of human rights in the United Kingdom is one of the oldest. An integral part of the UK Constitution, that is human rights, that have been derived from common law from statutes such as the Magna Carta, the Bill of Rights of 1689, and the Human Rights Act of 1998 from membership of the Council of Europe and from international law. Today, the main source of jurisprudence is the Human Rights Act 1998, which incorporated the European Convention on Human Rights into domestic litigation. The Act incorporates the rights provided in the European Convention of Human Rights, which essentially mean that the citizens can agitate the violation of their rights in the British courts instead of going to the European Court of the Human Rights. The Act requires all public bodies like courts, police, and hospitals to respect the human rights that are guaranteed to individuals under this Act. In India, the explicit inclusion of the fundamental rights in the Constitution is inevitable because of a number of reasons. Firstly, British rule saw large-scale violations of human rights in the country. Many of the constitution makers were themselves incarcerated by the British during the freedom struggle, and therefore they had a positive and dynamic approach towards the fundamental rights. Secondly, our Indian society was fragmented into various religious, linguistic, and cultural groups, and fundamental rights were needed to give all citizens a sense of security and confidence. Having said that, India today has totally been able to maintain its sense of upholding liberty, equality, and fraternity by providing social justice and economic justice as guaranteed by our Constitution. The preamble of the Constitution of India gives 3 dimensions of equality, which include civic, political, and economic equality. It means that there shall be no segregation on the basis of religion, caste, gender, and place of birth. It implies that everybody is viewed as equivalent in the eyes of law, and there shall be no separation or differentiation on any of the above grounds. Important court rulings in India have significantly altered the law and the way it is currently interpreted. One such landmark judgment which shaped is K.S. Puttaswamy versus Union of India of the year 2017. Retired High Court Justice K.S. Puttaswamy challenged the legality of the Aadhaar scheme, that is the unique proof of identity in regard to the right to privacy, by filing a petition in the Supreme Court against the Union of India. The subject was brought before the Constitution bench in response to the earlier court rulings so that it could be determined whether or not the right to privacy was recognized as a separate fundamental right under the Indian Constitution. A 9-bench of India's Supreme Court issued a landmark decision upholding the fundamental right to privacy guaranteed under Article 21 of the country's Constitution. In other words, it is held that privacy was an inherent component of Part 3 of the Constitution of India. It defended the Aadhaar legislation by claiming that the collection of demographic and biometric data does not violate the fundamental right to privacy because the information which is collected is limited solely for identification purposes. The Supreme Court also stated that the state must strike a balance, a careful balance, in fact, between individuals' privacy and legitimate goals at all costs, because legislation cannot grant or take away the basic rights, and all laws and acts must adhere to the Constitution. The world is slowly but surely overcoming the evil of inequality. We are gaining the ability to value people more for who they are opposed to their gender. As we become more aware of how crucial women's equality and empowerment are in today's society, numerous legal developments have been introduced. One such development was the amendment of Section 6 of the Hindu Succession Act 2005. Earlier, daughters had no co-partnership right and were only able to inherit their father's property indirectly, and they were not entitled to inherit the family's ancestral property through birth. This amendment established the right to co-partnership for daughters from birth with the goal of providing equality. In Vinita Sharma versus Rakesh Sharma and others, the Supreme Court of India in the year 2020 made a significant ruling that the Hindu Succession Amendment Act 2005 will take effect retrospectively. Under the amendment, the daughter of the co-partner was declared a co-partner by birth in her own right in the same manner as the son. The goal here was to adhere to the constitutional principle of gender equality. India is a democratic country, and thus laws are enacted to ensure that citizens live lives of respect and dignity. Indian law has undergone significant developments over time. The meaning of death penalty has evolved in India as a result of numerous rulings. Punishment meted out to offenders in the country for crimes and wrongdoing have typically been employed, in fact, as a sort of redress as well as a lesson for the public. This system has been around since the beginning of time and is still used now. The death penalty or the capital punishment is always regarded as the highest punishment that man has ever known. The Nirbhaya gang rape case was one of the most heinous rapes to ever occur. It jolted the conscience of people from all walks of life. The crime occurred on December 16, 2012. Soon after the incident, many significant legal developments occurred, and the 4 accused were finally sentenced to death on March 20, 2020. Due to extremely horrific and the barbaric nature of the crime involved, this case is considered as one of India's landmark case and has resulted in numerous modifications of the country's rape laws. The crime was so heinous that it was high time to re-examine the sexual assaults on the women and the children. In furtherance to this, a number of reasons contributed to transition from having no law to having a unique status like the POSCO Act of 2012, that is the Protection of Children from Sexual Offences Act. The Ministry of Women and Child Development strongly supported the POSCO Act in order to effectively combat the horrendous crimes of sexual abuse and sexual exploitation of children through clearer and more strict legislative requirements. The Act was amended in the year 2019 to include provisions for stiffer penalties for certain offenses in an effort to deter offenders and guarantee that children grow up with a sense of dignity and safety. The Act defines different types of sexual abuse and considers a sexual assault aggravated in certain circumstances, such as when the child who is abused is mentally ill or when the abuse is committed by someone in position of trust or authority over the child, such as a family member, doctor, or a teacher. And then I would like to say that constitutional position of even the Indian Prime Minister to come to the constitutional scheme of country is modeled on the British Prime Minister model, but with one difference. In India, a Prime Minister can be a member of either House of Parliament, that is the Lok Sabha or the Rajya Sabha. However, this is not so in Britain. It is the convention in Britain that the Prime Minister will always be a member of the lower house, that is the House of Commons only. British legal system is completely based on the common law system. Common law system implies that law is developed by the judges through their decisions, orders, or judgments, also referred to as the precedents. But unlike the British system, the Indian system incorporates the common law system along with the written, statutory, and the regulatory laws. And I would like to put forth here that the concept here of Vasudhaiv Kutumbakam that needs to be followed throughout the world in order to maintain a state of peace and serenity in the world and its members. The term comes from the ancient Sanskrit term Vasudeva, which means internal reality, and Kutumbakam, meaning family. The phrase Vasudhaiv Kutumbakam is made up of three Sanskrit words. Vasudhaiv, that means the earth and the world. Eva, which means the like, and Kutumbakam, large extended family. So the word find also mentions in Maha Upanishads and is referred to as the Hitopadesha and other literary works in India. The world can only function in a state of harmony when each and every citizen of this planet considers each other to be part and parcel of each other. That is when they do not discriminate each other on the basis of caste, religion, color, race, and profession. This golden principle should be followed by each and every national of the world, and all should work in harmony and peace by considering each other as one. The day this principle is followed by the citizens of the world graciously, this place shall certainly become a better place to live in. And on that note, I would like to end by quoting Dr. B.R. Ambedkar, which says, quote, "A just society is that society in which ascending sense of reverence and descending sense of contempt is dissolved into the creation of a compassionate society." Thank you. Thank you so much.
Thank you, Your Ladyship, for the beautiful words. Chairman sir, would you like to say something?
The type of discourses and narratives, it's really I was amazingly I was listening. Your Lordship, I think you should visit us for some time and interact with the students at least for an hour, and the amount of in-depth analysis just you carried out, our students will be highly benefited, including all of us. So thank you very much.
Thank you so much. It will be my pleasure. Thank you so much.
Thank you so much, Your Ladyship, Honorable Ms. Justice Mini Pushkarna, ma'am. Beautiful address, ma'am. And today at this international forum, with your beautiful address, I can remember Winston Churchill, who once said that all the great things in life are very simple, and that many can be expressed in simple words of freedom, hope, mercy, and justice. And also B.R. Ambedkar, who said that you cannot achieve that social democracy unless and until there is political and economic democracy. While all of these aspects are covered in the Indian Constitution, we hail the Indian Constitution and Honorable Prime Minister of India, who has given us this G20 presidency per year. I'm sure that all of us together can make India a Vishwaguru, like we always talk about, and lead the world with the great power of knowledge that we have. And at Amity University, Uttar Pradesh, we believe in the ideals of our founder president, Dr. Ashok K. Chauhan, who says that all of us are assets to the society and the nation. Thank you so much, ma'am, for your beautiful address.
Thank you.
Having said so, ladies and gentlemen, it's a proud privilege and pleasure to have with us none other than our distinguished guest of honor, Honorable Mr. Justice A.H.M.D. Nawaz, sir, Honorable Judge, Supreme Court of Sri Lanka. Justice Nawaz is the judge of the Supreme Court of Sri Lanka. Prior to his elevation, he has been functioning as the president of the Court of Appeal of Sri Lanka. Before his lordship was elevated to the judiciary, first as a judge of the Court of Appeal of Sri Lanka in 2014, he had long been serving in as the Attorney General's Department of Sri Lanka as a State Counsel, Senior State Counsel and Deputy Solicitor General. In the year 2005, when he was serving as a senior prosecutor in the Attorney General's office, Justice Nawaz won the prestigious British Shivering Scholarship awarded by the Foreign and the Commonwealth Office of the United Kingdom and pursued his LLM in Commercial and Corporate Law at King's College London. He was awarded his LLM with a merit by the University of London in the year 2006. In the year 2008, Justice Nawaz won another prestigious scholarship from the United States of America. He was awarded the Fulbright Humphreys Fellowship by the US government, and on this prestigious Fulbright Fellowship, he pursued his second LLM in Transnational Criminal and Commercial Law at Washington College of Law, American University. As a Fulbright scholar, Justice Nawaz had the privilege of being chosen by two international law firms of the United States, such as Arnold and Porter LLP and Squire, Sanders and Dempsey LLP as a foreign attorney, and he vigorously took part in arbitration and world trade law practice of the two American law firms. Justice Nawaz also secured his third LLM in constitutional law and administrative law from the Faculty of Law of the University of Colombo. Justice Nawaz's basic degree, that is LLB, is from the Faculty of Law of the University of Colombo. At Sri Lanka Law College, he was placed in order of merit out of 425 students in the entrance exam, and he secured a first-class honors in his intermediate examination. Justice Nawaz, while serving in the Attorney General's Department, extensively appeared in both domestic and international litigation of Sri Lanka. He was a constant delegate on behalf of Sri Lanka to the United Nations Human Rights Council from 2010 to 2014. With this repertoire of forensic skills and academic achievements in law, his lordship is a much sought after visiting faculty at both domestic and overseas university. His lordship has extensively graced many an academic and judicial colloquia in India, and his interest lies in comparative jurisprudence. Ladies and gentlemen, it is with much delight, pleasure, honor, and respect that I would now invite our distinguished guest of honor, His Lordship Honorable Mr. Justice A.H.M.D. Nawaz, Judge, Supreme Court of Sri Lanka, to present his address. Over to you, respected sir.
Thank you very much. I hope that I can be heard. Am I audible?
Yes, sir. You're audible and we can see.
Right. Thank you very much. It's indeed a great pleasure to join virtually Amity Law School. The ambience of Amity Law School is not unknown to me, having taken part in some of your interesting sessions in the past. So when the invitations came to me, it was like a kindred soul raising a chair from India to virtually join you, and I gladly accepted this invitation. I must tell you, on this grand occasion of imparting and sharing some common themes and values on the diverse aspects of law, Amity Law School is doing great honor. And whether it be a common law system or a civil law system, we cannot hide the fact that in this diversity lies several similarities, several strands of unity, and that, of course, highlights the necessity for a constant exchange of this nature to strike out in the directions of comparative developments that will stand our legal system in good stead in the times to come. Anyway, I should acknowledge at the outset something that has been bothering me, the existence of a body of opinion which regards this comparative jurisprudence at best irrelevant. Some schools of thought do exist that the comparative jurisprudence is inapposite. I must, of course, tell you that the biggest advocate of that school was Justice Scalia. He expressed the view that in a human rights context, he said some time ago that he virtually regards foreign authorities as meaningless dicta, and he even went to the extent of ruling that the court should not impose foreign moods, fads, or fashions on Americans. This is what he said. But of course, the majority in the US Supreme Court, which I had the occasion of witnessing several times in my school days, did not share that opinion. The majority wrote a different opinion to that of Justice Scalia. Let me place that at the front of my speech today, just to tell you how differing and divergent the judges are in borrowing principles across the passport control. I must tell you, lots of judges have drawn their attention to lots of differences of legal culture, tradition, education, and statutory background between one country and another. It is an axiom that we differ in several respects. As a result, we have the difficulty of seeking to assimilate a foreign law in anything approaching an accurate or comprehensive way, and to the even greater difficulty which arise when foreign law is accessible to the judge or practitioner only through the medium of translation. I have had that difficulty of accessing some judgments from across the world, and I have some fantastic judgments which are accessible only in the language of its origin. But of course, I have had the pleasure of wading into the Indian jurisprudence since English is the common binding tie. I have derived immense pleasure at that comparative richness of Indian jurisprudence. Of course, I must thank my research engines, which I richly use, LegitQuest and SEC Online, which are freely available to me, on which I access Indian material. And I must say, there's a creeping influence of those Indian precedents in my judgments. Be that as it may, I must also say the fact that your interactive sessions yesterday and today has given the participants, I must say, so much food for thought. It really goes a long way to strengthen the synergy between the judiciaries and the legal fraternity. And we are very thankful that Amity Law School, Noida, hosts this international conference on comparative law in an unbroken series in order to achieve the objective of imparting the latest developments in law, whilst this exercise will also result in great bonds of friendship and continued engagement. On this valedictory session, I thought of sharing with you some common strands of uniformity that inform the two legal systems, namely India and Sri Lanka, which in turn show cause also our common heritage. Both in regard to substantive and procedural law, we have common origin. Why I wish to reflect on these common bonds is because our meeting today virtually is to reinforce the value of comparative jurisprudence. I hold a strong view vis-a-vis Justice Scalia that no two legal systems can develop in isolation, particularly when their ancestral origins are the same. It is undisputed that English law, which is called the common law all over the world, has influenced our two legal systems, India and Sri Lanka, to a great extent. Though English law governs the law of Sri Lanka in diverse areas, such as commercial law, banking, and international trade law, I must also sound a caveat that Sri Lanka is also an heir to the Roman Dutch law tradition because the Dutch ruled us some time ago. In fact, the Roman Dutch law is called the common law of this country, though English law plays a truly significant role in Sri Lanka. We have the nexus to the English law, the necessity, even though we gain independence from the United Kingdom in the year 1948, we still retain English law because the British enacted in Sri Lanka an ordinance called the Civil Law Ordinance in 1852, introducing English law in commercial disputes. Because of that, English law survives today. And we also borrow English law in a great way in lots of our other diverse areas of litigation. So we cannot deny then, in those circumstances, that the common heritage between India and Sri Lanka is owed so much to English law, as we were colonized and ruled by the British for a long time, until our respective independence in 1947 and 1948. I can speak of several examples where the Indian enactments made by the British were transplanted into Sri Lanka. Something that comes to my mind is the Evidence Ordinance of Sri Lanka. It is, of course, based on the Indian Evidence Act of 1872 with some important modification. We all have to be thankful to that architect, Sir James Fitzjames Stephen. He was involved in the drafting of the Evidence Act, Indian Evidence Act, and he was invited. That's something which really attracts me. I keep saying that he was invited to introduce that legislation in the Indian legislature. It was a tribute to Sir Stephen's excellent drafting that we followed suit in adopting this act and enacted our own ordinance in 1895. But there are differences, slight differences between the English, the Sri Lankan Evidence Ordinance and the Indian Evidence Act. Leave that aside. Even our Civil Procedure Code, I must tell you, is greatly enriched by the Indian Civil Procedure Code of 1877. We keep saying that there's an English judge who said Sri Lankan Civil Procedure Code is a copy of the Indian Civil Procedure Code, slightly altered, and that our code closely follows the Indian code in the matter of pleadings. As a result, whenever I have the need to refer to a section, I always resort to Indian judgments on similar provisions in the Indian CPC. The penal code, the Indian penal code itself came from Lord Macaulay, and the Sri Lankan penal code is no exception, and it percolated across the Pork Straits. Now, the major area which I practice now in the Supreme Court, apart from the appeals, is the constitutional law and fundamental rights. The similarities between our two jurisdictions are more than they are dissimilarities. And even in the interpretation of fundamental rights, which was made justiciable for the first time in Sri Lanka in the 1978 constitution of ours, the Indian authorities have had a tremendous influence. Just as the constitutional law of India has borrowed from American jurisprudence, so has the judiciary in Sri Lanka. And in the initial days, after Chapter 3 containing fundamental rights came to be litigated in Sri Lanka, a number of Indian judgments shaped the thinking and growth of our own jurisprudence. In the Indian case of People's Union for Democratic Rights versus Union of India, writ petition of 1981, which is known as ASAAD case, the actual violations of fundamental rights took place at the hands of private contractors, but the state was held responsible because it had chosen to enter into the contract with those who violated the fundamental rights. This principle has had its creeping influence into the Sri Lankan fundamental rights jurisdiction. And our Supreme Court has oftentimes quoted the words of Indian Supreme Court interpreting the equality clause in Article 12(1) of our own constitution. And of course, the Chief Justice Bhagavati's words in the case of Gupta versus Union of India, 1982, All England Reports, page 149 at 197. Those words ring very much in our jurisprudence. within quotes, if there is one principle which runs through the entire fabric of the Constitution, it is the principle of the rule of law. And under the Constitution, it is the judiciary which is entrusted with the task of keeping every organ of the state within the limits of the law and thereby making the rule of law meaningful and effective. It is to aid the judiciary in this task that the power of judicial review has been conferred upon the judiciary. These are powerful words we have borrowed. Of course, I must refer to Article 21 of the Indian Constitution. Just like the 1978 Constitution of Sri Lanka, the Indian Constitution contained chapters relating to fundamental rights and directive principles of state policy to ensure protection of dignity and equality inherent in all human beings. They are pledged to promote and encourage respect and observance of human rights and fundamental freedoms of all groups of people. The purpose, object, and aim, Universal Declaration of Human Rights 1948 are pragmatically incorporated in the Indian Constitution, and Article 21 is at the heart of that Constitution. It is well settled by the repeated pronouncement of your apex court that right to life enshrined in Article 21 is not of mere survival and existence, guarantees the right of persons to life with human dignity. Therein are included all aspects of life which go to make a person's life meaningful, complete, and worth living. The expression life in Article 21 of your Constitution does not and cannot merely be physical or animal existence. These words are very powerful. The right to life includes the right to live with human dignity. Further, it was laid down in the case called Santistan Builders versus Narayan, that considering the width and ambit of Article 21, the right to life would take within its sweep the right to food, the right to clothing, the right to clean environment, and reasonable accommodation to live in. In other words, the Supreme Court of India has expanded the scope of Article 21. In the case of Board of Trustees of the Port of Bombay versus Raghavindranath Natkarni, 1983, 1 SEC 124, your apex court has recognized the right to reputation as a facet of right to life of a citizen under Article 21 of the Constitution. Of course, Puttaswamy's case was referred to. Its tremors, its vibrations have not spared the Supreme Court of Sri Lanka. Puttaswamy we have taken cognizance of, and right to life, which is not explicit in our Constitution, will one day find its expression through Puttaswamy very soon in the jurisprudence, I believe. So we see the exponential interpretation across the pork trade in the Indian Supreme Court, and we derive a great deal of inspiration by those words coming from your Supreme Court, and having felt the necessity to expressly incorporate right to life, now efforts are afoot to do so in the proposed new Constitution. I must also tell you, even yesterday, I came across a case in which public interest litigation was mooted. Justice Bhagavati's innovation, namely public interest litigation, is today widely practiced in Sri Lanka, and our Supreme Court is now prepared to entertain an application under the Fundamental Rights chapter in the form of public interest litigation, even if there is no specific complaint that the petitioner's own fundamental right has been violated. The epistolary jurisdiction has found its way, so I only am highlighting all this just to tell you how much comparative jurisprudence has enriched and enlarged the jurisprudence of each other. This showcases the apparent symbiosis and synergy that exists between the Sri Lankan courts and the Indian jurisprudence. If I were to speak of the English jurisprudence and the American jurisprudence, the time would not permit. So the thought that comes to my mind is that we have so many common law origins to nurture and nourish us, and we are the proud inheritors of great legal tradition. So cross-border transplants in legal jurisprudence has become the norm today, and India and Sri Lanka, and not only India and Sri Lanka, but also other countries like Lebanon and all other civil and criminal, civil and common law countries have a lot to benefit from each other, and this relationship would be strengthened a great deal by the interaction of this nature that you have continuously organized and then carried on with great aplomb for the last 3-4 years. So by thanking the Amity Law School, Noida, for organizing such a wonderful program of interactive sessions, I hope and trust that we will continue this partnership for a long time to come. I have no doubt that such a continuous engagement is bound to help both the Indian and other judiciaries. And I must thank you very much for the invitation. And it gives me great pleasure to share these thoughts of an afternoon. And in fact, there is an impending visit of mine to India next month, to another university. And it's indeed a pleasure to fly across the Pork Strait and visit my friends, both in the judiciary and the legal fraternity. And I will certainly accept this invitation when it comes from your Amity Law School, which I value so much from among the law schools in India. Thank you very much. And it's a vibrant interaction.
Exactly. Yeah, your Lordship, Justice Ahmad Nawaji, I was astounded. I was astounded by your speech. I was just, I was telling that, how much with confidence, with analysis, with deliberations, and depth, you have actually put it in your heart, not in your brain. So you spoke from your heart, not from your brain. It is really, really very fascinating to listen to you. This is the second time we are meeting you, and second time we have been enriched by your deliberations. Now, as you are coming the next month to India, so could we, send your itinerary to us so that, in case we can find a slot, so if you can interact with our students, they will be highly benefited, because we have just brought the comparisons about the Sri Lanka Constitution and Indian Constitution, the type of symbiosis and the synergy. That's the word, symbiosis and the synergy that you have brought in. I think our students will be highly benefited, and this may give them is a different types of approaches in learning Constitution. And the way we teach Constitution again requires a different way of treating them, different way of handling them. So that will also bring forth a new arena of looking at those issues. So really,
thank you very much.
I was astounded. I was really amazed by listening to your lecture. So thank you, sir. Thank you very much.
I'm also amazed by the energy that you are exhibiting from there, from that end, and interacting with us. It's quite engaging. And so an Indian visit always inspires us, having been neighbors just across 22 miles, and it's indeed quite vibrant for us to come to India. And I have very fine friends there on your faculty, Mr. Rupendra Singh and Jane Iyer, who have maintained constant links with me. And if not for their kind invitation and their constant nudging, I would have been on the program. And then so they have been behind me all the time. Thank you very much,
sir. Just in 130 seconds, I'll take that. Jane Matthew and Rupendra Singh, they have actually not nudged you, but they have actually started appreciating you so much. Yeah. They could not but to remain in touch with you. I mean, that is the beauty. And that is the beauty of Amity Law School, Noida, sir.
Thank you. So thank you. All the best to you. Thank you.
Thank you so much, Your Lordship, for the beautiful address. And thank you so much, Madam Ladyship, for your beautiful addresses. Ladies and gentlemen, boys and girls, what a great pleasure and delight to listen to justices learning so much about liberty, equality, and fraternity through different judges in different countries. This reminds me of Ambedkar, who said that justice is yet another name for liberty, equality, and fraternity. That is what we are looking for across the globe. And Justice Nawaz sir and Najat ma'am, welcome to India anytime you are here. That is what Justice Nawaz just said. It's vibrant, quite vibrant in India. So welcome to Vibrant India, what we call as Incredible India. Ladies and gentlemen, we would now be presenting citations in the honor of our distinguished guest of honors who graced this virtual dais today. I request Honorable Chairman, Professor Dr. D.K. Bandyopadhyay sir, Conference Chairperson, Additional Director and Joint HOI, Professor Dr. Aditya Tomar Sir. Additional Director and Joint HOIs, Professor Dr. Shefali Raizada Ma'am, Professor Dr. Arvind P. Bhanu Sir, to virtually present the citation in the honor of our distinguished guest of honors who have graced this occasion. And the citation reads, the citation is presented to Honorable Mr. Justice A.H.M.D. Nawaz in the valedictory ceremony of the International Conference on Comparative Law on Saturday, the 11th day of February 2023. His Lordship is the sitting judge of the Supreme Court of Sri Lanka and an academician at heart. He has contributed to the development of legal jurisprudence of Sri Lanka tremendously and has a zeal for learning something new, which is evident from his varied areas of acumen. We are thankful to His Lordship for contributing immensely to this conference and for sparing his valuable time. We hereby recognize the contribution made by Honorable Justice Nawaz and extend our sincere thanks to him, presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and the School of Business and Law, Edith Cowan University, Western Australia. Thank you, sir, for gracing the occasion. Please accept our citation.
Thank you. Thank you.
Thank you so much, sir. We will now be presenting the citation to Honorable Ms. Justice Mini Pushkarna, and the citation reads, the citation is presented to Honorable Ms. Justice Mini Pushkarna in the valedictory ceremony of the International Conference on Comparative Law on Saturday, the 11th day of February 2023. Her Excellency is a serving judge at the Delhi High Court. Her ladyship has been instrumental in pronouncing several judgments of social importance. We express our heartfelt gratitude to her ladyship for gracing this occasion and imparting a motivating address. We hereby recognize the contribution made by her ladyship and extend our gratitude to her, presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and the School of Business and Law, Edith Cowan University, Western Australia. Your ladyship, please accept her citation.
Thank you. Thank you so much.
Thank you, ma'am. We are so humbled in her presence. We will now be presenting the citation to Honorable Ms. Najat Abu Chakra, ma'am, and the citation reads, the citation is presented to Honorable Ms. Justice Najat Abu Chakra in the valedictory ceremony of the International Conference on Comparative Law on Saturday, the 11th day of February 2023. Her Excellency is currently serving as the investigative judge at the military court in Beirut. She has also served as the penal unit judge at the Ali Court and was a member in the first instance chamber in the south of Lebanon. We express our heartfelt gratitude to Her Excellency for sparing time and sharing her inputs. We hereby recognize the contribution of Her Excellency and extend our sincere thanks to her. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Your ladyship, please accept a citation.
Thanks a million. Thanks a million, Dr. Zink. And I'm so honorable and I feel really so proud to be with you today. Thank you so much.
Thank you so much, ma'am. We are equally humbled and honored. Thank you so much. Well, ladies and gentlemen, moving ahead in the schedule. Many papers were presented during the two-day conference, and it was a tough job selecting the best paper and the second best paper. So I will now request Dr. Jane Iyer Matthew, who is the Assistant Professor and Conference Convener of ICCL 2023, to announce the results of the best paper and the second best paper. Over to you, Dr. Jane.
Thank you so much, Dr. Sumitra. Now we have come to one of the most awaited part of the valedictory session. This fourth International Conference on Comparative Law has seen the maximum number of keynote speakers and technical sessions in terms of the previous year's conferences that we have held. Now, this year, the main themes for the conference was comparative constitutional law, comparative criminal law, comparative business law, comparative family law, comparative IPR technology law, and emerging legal domains. Now, we have received around 200 abstracts across the themes from both national and international participants, of which, after reviewing, we had accepted 90 papers for presentation in 8 technical sessions, which was held today. Now, I'd like to start with technical session 1, the results for the technical session 1. The best paper for technical session 1, which was on comparative constitutional law, goes to Dr. Liji Samuel, Associate Professor, Department of Law, Central University of Kerala. And the second best paper goes to Dr. Indrani Kundu, Assistant Professor, Jogesh Chandra Chaudhary Law College, affiliated to University of Calcutta. Technical session 2, again, the theme was comparative constitutional law. The best paper award goes to Ms. Sheena Das, research scholar, Hindustan Institute of Technology and Science, Chennai. And the second best paper goes to Ms. Manvi Raina, research scholar, Department of Strategic and Regional Studies, University of Jammu. The third technical session, which was on comparative criminal law, the best paper goes to Dr. Purnima Khanna, Assistant Professor, Khalsa College of Law, Amritsar. And the second best paper goes to Mr. Setu Gupta, Senior Research Scholar at the Indian Law Institute, New Delhi. Technical session 4, the theme was comparative criminal law and human rights. The best paper goes to Ms. Shailja Khosla, research scholar, Amity Law School, Amity University. And the second best paper goes to Ms. Radhika Sharma, research scholar, University of Jammu. Technical session 5 on comparative IPR, technology laws and emerging legal domains. Best paper goes to Ms. Tarushi Acharya and Dr. Ravindra Kumar Tevatia, Assistant Professor, Law Department, TIPS, Greater Noida. And the second best paper goes to Ms. Mini Srivastava and Ms. Aishwarya Dubey from Amity Law School, Noida. Technical session 6, again, the theme was comparative IPR, technology laws and emerging legal domains. Best paper goes to Ms. Safa Shamim, student of St. Joseph's College of Law, Bangalore. And second best paper goes to Ms. Tanzeem Afroz, research scholar, Amity University. Technical session 5, which was, the theme was comparative business law. Best paper goes to Dr. Sujata S. Patel from the School of Business and Law, Navrachna University, Vadodara. And the second best paper goes to Ms. Tulika Danai and Dr. Mamta Rana, research scholar and associate professor from HNB Garhwal Central University, Uttarakhand. The last session, which was technical session 8, the theme was comparative family law and human rights. Best paper goes to Dr. Nirmala Devi and Ms. Supreet Kaur from Department of Laws, Guru Nanak Dev University and Chandigarh Law College, Mohali. Second best paper goes to K. Niranjana Devi, student of School of Legal Studies, Central University of Tamil Nadu, Tiruvarur. Now, congratulations to all the winners. And that's all from my side.
Thank you, Dr. Jain, and congratulations, all the paper awardees. A big day for you all. As I said, it's very difficult to find out which the best paper is. So congratulations to all the conference chairs and co-chairs of different technical sessions. It was a tough job. So many congratulations to all the winners. Well, they say that justice is the sum of all the moral duties, and justice remains at the core of any comparative jurisprudence. So keeping that in mind, I will now request dear friend and colleague, Dr. Kriti Parashar, who is the conference co-convener and assistant professor at Amity Law School, Noida, to present the entire conference report. Over to you, ma'am.
Thank you, Dr. Sumitra. Good evening, everybody. I'd like to take this opportunity to present the report of the 4th International Conference on Comparative Law 2023. Now, this conference was held in continuation of the prior series of International Conference on Comparative Law. This legacy is being continued with added vigor and valor for the past 3 years, and today we are at the end of the 4th edition of the International Conference on Comparative Law 2023, which is being jointly organized by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edmund Cowan University, Western Australia. The main theme of the conference was comparative law. In the conference, other than the inaugural and the valedictory, we had 4 keynote sessions. For the keynote sessions, we were addressed by 20 distinguished legal luminaries from around the globe. We were fortunate to have representation from some of the leading universities from around the globe. Professor Colin B. Pickler joined us from the University of Wollongong, Australia. We had addressing us Professor Mark Graber from the University of Maryland, Carey, United States. We had addressing us Professor M.P. Jain, Chairperson of Center for Comparative Law, National Law University, Delhi. Professor Stephen Wager from Max Planck Institute of Legal History and Legal Theory, Germany. Professor Paul T. Babi from the University of Adelaide, Australia. Dr. Surajit Basu from University of Leeds, United Kingdom, to name a few of the keynote speakers. The distinguished keynote speakers addressed the participants on multifarious aspects of comparative law. I would like to inform you that the keynote sessions were very thought-provoking and insightful. To give you a glimpse of some of the areas discussed, one of the pertinent areas discussed was the significance of application of comparative techniques of law so that there is harmonization and unification of law. Another area discussed was global combat of human rights in the matters of climate change and how companies ought to be accountable and the state held responsible to protect the people. Hence, the need for having a global climate change legislation was emphasized upon. Another area discussed was the artificial intelligence and law and emergence of artificial intelligence and its venture into the area of education and the problem it poses on the quality of education in terms of jurisdiction. Emphasis on indigenous solutions after understanding the pros and cons from across the globe in matters of insolvency and bankruptcy was another area which was discussed in the keynote session. Another area that was pondered upon was importance of comparative law in matters of corporate governance, human rights, democracy, rule of law as significant in matters of data sovereignty, the future of comparative law and the areas of extraterritorial space, restrictions and scope of the study of comparative law in areas like intellectual property law, artificial intelligence was also discussed by the keynote speakers. Another area that was discussed was comparative approaches to the study of law in common law and civil law jurisdiction, as well as in matters of public and private law. The present conference, as already discussed by Dr. Jain, incorporated several sub-themes like comparative constitution law, criminal law, media, IPR, technology law. We received more than 200 abstracts, and after reviewing them, around 90 papers were presented in the technical sessions held today in 8 different sessions. Also, taking forward the mandate of the National Education Policy 2020 with a vision to strengthen better placement and internship, we have ventured into entering into a partnership with industry partners. So MOUs were signed with 2 industry partners, namely MISBIS and Tech Mahindra. This conference has truly contributed in developing the jurisprudence of comparative law, and we intend to take forward the learnings of this conference to establish collaborations in teaching and research. We hope that all the participants have benefited from this conference. With this, I'd like to end the report for the conference. Thank you.
Thank you, Dr. Kriti, and you presented a wonderful report, and that also shows what a grand conference ICCL 2023 has been. Thank you so much. Well, ladies and gentlemen, at Amity University, modernity blends with tradition, and research and innovation go hand in hand. Having said so, it's time that we release the books for this conference at the valedictory ceremony. Yesterday, during the inaugural, also we had released books. Right now, we are releasing the book of abstract. This is, I would request Rupendra sir to share the screen, please. Yes, ladies and gentlemen, we are now releasing this book of abstracts, which is the proceedings of the 4th International Conference on Comparative Law held on 10th and 11th of February, which is co-organized by Amity Law School, Noida, and School of Business and Law, Edith Cowan University, in the presence of Chairman Amity Law Schools and together with additional directors and joint HOI, presenting to you the book of abstracts. Let's have a round of applause for these proceedings. So the conference took place on 2 days on different aspects of comparative law, and This book deals, this abstract books has got proceedings. That means abstracts of all the presenters who have presented papers today, and also the abstracts of all those who have won awards today. So a great day. And as you can see, the contents, there have been chapters on constitutional rights and liberties, and there are papers presented on Constitution, Indian Constitution, socio-legal study of LGBTQ, and you can see varied and myriad topics related to media protection, related to rights by the act of judicial activism, developments in the Indian Constitution, principles of liberty and equality in different countries, say US, Canada, and India, presented by so many authors. It talks about different quests towards attaining global standards, ensuring peace and justice. So the book is ranging on different themes, and the papers have been selected in that ways. Congratulations, Amity Law School, Noida, and School of Business and Law, Edith Cowan University, for release of this book on abstracts. Now we will release another book in the presence of Honorable Chairman, Your Lordship and Leaderships. This book is titled Comparative Approaches in Law and Policy, and edited by Dr. Joshua N. Aston, who is the Conference Chairperson Australia of International Conference on Comparative Law 2023, together with Professor Dr. Aditya Tomar, sir, who is the Conference Chairperson India for ICCL 2023, and Dr. Jean Iyer Matthew, ma'am, who is the Conference Convener. This book is published by Springer. Congratulations, Amity Law School, Noida, and Edith Cowan School of Law and Business for the release of this book at the International Conference. Congratulations. Well, that brings us down to closure of the ceremony, but you will have to wait for 5 minutes because we cannot leave you like that. We will be presenting a vote of thanks and also our sense of gratitude with the help of a video. I will now request Professor Dr. Shifali Raizada, ma'am, our dear Additional Director and Joint HOI at Amity Law School, Noida, to present a vote of thanks. Over to you, respected ma'am.
Okay, thank you, Dr. Sumitra. Very good evening to everyone. Now we are at the closing of this two-day conference, international conference, which was in the collaboration with our university partner, Edith Cowan University, Western Australia. And it's a wonderful experience of the 2 days, hard work, and lot of insights and insightful, informative kind of the conference took place. So with all mighty God's grace, I would start with our founder, President Sir Dr. Ashok K. Chauhan's blessings, as he has always been with us, and we are really thankful as he has provided that platform, Amity, so that we can fulfill our aspirations, and he has given the vision for all of us to have the roadmap of our life and our wishes to fulfill. So thank you so very much, our founder president, sir. I'm very thankful to our chancellor, sir, Dr. Atul Chauhan, sir, for giving the ecosystem for the research and innovation at Amity, and also always there to support and guidance for this for making this university as the research-driven and innovative platform. So thank you so very much. I'm very thankful. I convey my highest regards to our very dynamic Honorable Vice Chancellor, Ma'am, Professor Balwinder Shukla, ma'am, for all guidance, for upkeep our motivation, for giving the support and also the directions how to go for further and further in our academic life. So thank you so very much, ma'am, for giving such a wonderful platform and always be with us. Further, I convey my regards and gratitudes to our chairman, sir, Professor D.K. Bandyopadhyay, sir, for giving all support, guidance, and I always use the word as the backbone of the Amity Law School for providing all support, all guidance, all directions and motivation. Always he is of the opinion that we are the academicians and we have to throw the path and we have to move on the road of research because it starts with the knowledge. We have to use our knowledge and skills for the further. Now the knowledge is the we have to encash our knowledge and skills. So thank you so very much for being our chairman of the Amity Law School, Noida. Thank you so very much. Apart from this, our authorities,
this is my time, and I just take this privilege to convey my highest regards and gratitudes to all the esteemed speakers and the guest of the honor for the day on this occasion of the valedictory. First of all, I convey my regards to Honorable Mr. Justice Ahmed Nawaz, Judge, Supreme Court of Sri Lanka. Sir, I was listening all your insightful enlightenment and the beautiful words, how you have deliberated to throw a light on the various aspects related of the issue and related of this comparative law. Thank you so very much. And I believe that this is the real platform where we could have the comparative law between the two nations. So thank you so very much for coming and sparing the time. We are really obliged. Further, I convey my regards and gratitudes and a big thank you to Honorable Miss Justice Mini Pushkaran ma'am, Delhi High Court. Ma'am, really what you have elaborately, what the information and insight you have given on the issue and covering the entire and various related areas. It was a wonderful discourse on your part. And they have given the new horizon to think over the issue. So thank you so very much for coming and sparing the time for Amity Law School, Noida. We would like to have you again in the physical mode very soon. Thank you so very much. Further, my thanks to Honorable Ms. Najat Abou, Chakra Investigative Judge, Military Court, Lebanon. Yes, ma'am. Really, I was listening your inputs in the area as you have given various examples, how the investigation and how the comparison and comparative mode and comparative approach is fruitful in the various criminal justice system or other justice system to give a new input in the framing of the legal structures of the various nations. So it was a wonderful insight and the new inputs and the new directions and a new thought process you have given. So thank you so very much. Now, I will convey my gratitudes and a big thank you to all the keynote speakers. As Kriti has given the number 20 keynote speakers, but I will include all the speakers, whether they were the paper presenters or maybe the keynote speakers. Wonderful, because as many as speakers we got the various issues, various inputs. And I believe it was a think tank now for the comparative law, and it is difficult to disseminate and to segregate in terms of the importance and all. I think each and every point was a treasure for the field. So thank you so very much, all the keynote speakers, paper presenters, and I appreciate the good number of the papers have been selected for presentation, and they deserve a lot of applaud. They deserve a lot of appreciation from all of us. So thank you so much for all the paper presenters and the best paper awardees. A special thanks and a special congratulations to all of you. So thank you so very much. Now the organizing team, a big organizing team, including the Dr. Jain, Rupendra, Kriti, and the Dr. Sumitra, and so much of the other faculty members of the various committee. You really did a lot of hard work. I know a lot of efforts and inputs. Diligence is there, and you have given your 100%. So a lot of praise and lot of appreciation, lot of applaud. You deserve a lot. I again come to the student committee, conveners and student committee. Yes, without the student support and students, I believe the student base or the ground, they have prepared the ground on which the Amity Law School is standing and moving ahead. So thank you so very much, the student committee, administrative staff, IT committee, and media team. Thank you so much for all facilities, support system you have provided to us so that successfully this event has gone now going to be over. So I acknowledge your present, your support is here and very much acknowledged and very much applauded. So thank you so very much, everyone. Everyone needs a lot of appreciation and a lot of applaud. So thank you so very much, everyone. And thank you once again. Thank you.
Thank you so much, Professor Dr. Shafali Raizada, ma'am, for your beautiful words. You always touch our hearts with beautiful words and with your love for us. Thank you so much, ma'am. Well, everybody, I remember Theodore Parker who once said that the arc of moral universe is very long, but it bends towards justice. And as Francis Bacon says, if we do not maintain justice, justice will not maintain us. So that is the core of any comparative law discussion, and that is what we had in the International Conference on Comparative Law Valedictory Ceremony, and 2-day sessions were discussed elaborately about different laws. So finally, we come towards the closure of this ceremony, and we wish everybody a very beautiful future. As we discussed in the 2 days international conference, we also discussed about unification of the laws and how laws are different in different countries. What can be done to solve the global problems? I'm sure with both solutions and with great dynamism, we will come back again with the 5th edition of International Conference on Comparative Law. With this small video, we are expressing our deep sense of gratitude and love from Amity University on behalf of our founder president, Dr. Ashok K. Chauhan. This is a short video to showcase our gratitude for you. Thank you everyone who made ICCL 2023 a great grand success. This is for you. That's it. Thank you so much, Upendra sir, for sharing the video. Well, everybody, it's time to close this session. On behalf of our Honorable Founder President, Dr. Ashok K. Chauhan sir, goodbye and God bless everybody. With your permission, Your Lordship, Madam Ladyship, and Chairman sir, can we close the session?
Yes.
Okay, bye-bye, everybody. Take care. We'll meet again with the 5th edition of International Conference on Comparative Law 2024. Bye-bye and take care till then. Bye-bye. Take care, everybody.